Now, back to On the Market on 105.9 The Region.
You're listening to 105.9 The Region. Welcome back to On the Market, York Region's only radio real estate show. I'm station manager Tina Cortez, and my co-host is Asif Khan with RE/MAX Prime Properties.
Thank you, Tina. Joining us next is real estate lawyer and broker owner from RE/MAX Empire Realty, Ricky Rathore. Ricky, welcome back.
Hey, thanks, guys. Thank you for having me.
Ricky, it's already August. Can you believe that?
Unbelievable. Time flies, eh?
It sure does. And what a summer it's been for real estate in York Region.
Yes, it's been one hell of a season, that's for sure.
Ricky, we often get people closing, and we talked about this last time you were on the show on things that sometimes fall apart, but we had a call from one of our clients that moved into a property, and the previous owners had left a whole bunch of garbage in the garage, in the basement, in the kitchen. What do you say to people when they call you and they have this exact same problem?
So, Asif, when you go out, as an example, and buy a brand new car, right, you expect that car to be delivered in the way that you purchased it, right? Clean, not with another 10,000 kilometers on it. In the same condition that you agreed to purchase it, you expect delivery subject to normal wear and tear. The same logic transfers over to real estate transactions. When you purchase a home, more often than not, your closing dates are between 60 and 120 days away from the actual time that you sign the offer and agree to obligate yourself to that contract. But the fact remains that the seller has an obligation to maintain that property in the same state that you agreed to purchase it in, and they can't just let it fall below standards once they've sold it.
Now, what's the protocol? So they contact their real estate agent. We say, hey, you know what, take pictures of it, send it to your lawyer. What do you guys do when you get these pictures or you get this phone call, a frantic phone call to say, hey, we came here yesterday, we saw the property, everything was fine, now we're moving in today, and we notice that there's a big gash from when they were removing the bed frame. What happens with that?
So there's two things. At our office, we're very proactive. And when we're signing the client, we're usually signing them the week of or the week before closing. And we tell them, look, you have to go to the property before the closing now because it's been several months since you agreed to purchase a home and you did your inspection. You need to now go in and re-inspect the property. A lot of brokers will change that inspect provision to 2 further visits or 1 further visit before closing, but it makes no difference. The fact is that prior to closing, as closest to the closing date as you can, you should go to the property and make sure it's in the same state that you agreed to purchase it in. And in addition to that, you want to make sure your contract is very clear as to the state of the property in terms of how it should be delivered to you by the seller. So by doing that inspection before closing, you can satisfy yourself as a purchaser that the property is in a reasonable condition when compared to when you agreed to purchase it. Now, sometimes you do all of this, or sometimes you just can't get in because you don't have the ability or the time to do that final inspection, in which case, yes, you'll call my office or your lawyer's office and say, hey, there's a whole bunch of tires sitting in the garage. It's going to cost me thousands of dollars to dispose of. That was a real situation that happened. And so at that point, transactions close, you've got the keys, everything's done, the contracts come to an end and merged, but you may be able to seek recourse in small claims court. Depends on the nature of the actual damage. But more often than not, like we've discussed previously, the cost benefit of pursuing a claim, it's usually outweighed by the costs associated with pursuing it. So most people don't go that far and usually do reconcile between the attorneys.
So the clause states, seller will leave the property in clean and broom swept condition. What does that actually mean?
Well, it literally means that. Clean and broom swept condition, right? You want to make sure that if you can be more expressive, no clutter, no garbage, no debris, lawn should be maintained, right? Simple example, you bought a property in let's say, April, May, springtime. And when you bought it, it was nice kept, garden was nice and groomed. Now you go in before closing, you have weeds and tall grass everywhere. That's not how you bought the property, right? So we actually had situations where realtors get involved. They get out the lawnmower, they call out a contractor, and they go and deal with it because the hassles and the experience is very important. They don't want their clients to go through the hassle. The experience of the client is very important to the realtor. And so they go out and they get on these, get these contractors out there to just remedy the property so the client doesn't have that experience. But if it does come down to the point where I have to get involved or a lawyer has to get involved, we send the letter, the other party might not, they might not do anything with it, and then you just have to afford the legal recourse that you may have available to you.
Now, do you get a lot of these complaints that it's just emotional responses by the buyers or sellers and there's not anything really there, but moving is very emotional, very stressful. So do you get a lot of complaints per se on things that you look at and say, come on, that doesn't really make any sense. It's not going to hold any weight.
All the time. And quite frankly, I think it's a lack of education. I think that once the contract's done, a lot of people say, hey, it's over. And especially from the realtor side or the mortgage side or even the lawyer's side, for the most part, it's like, okay, the client kind of should know or does know. There's expectations or assumptions being made. And so I think education is the key component. Clients should be educated. Hey, this is the offer. We accepted it. This is what's happened. These are the next steps. And these are the kind of things that we want to do to make sure that everything happens seamlessly. Sometimes buyers get really upset because their mortgage isn't working out last minute or things are happening. And, when you have unaccounted things come up before closing, of course you're going to become agitated and frustrated with the process, which obviously, increases how, aggressive you are towards the whole transaction towards the end. So it's that hand-holding that's important, and that's why it's so critical that you deal with a good realtor who has experience, who knows, what to do and how to handle situations based on the number of transactions that they've done, and a good real estate lawyer who can explain your contractual rights and obligations so you're not found in breach of contract.
And usually we're getting the 2 visits, and it's really important for them to trust us because the natural, fallback is we want to see this house next week with our parents, and we want to go back in 2 weeks because we're taking in our contractor. And we almost have to hold them back and say, let's get the contractors in when you're taking your parents because we want to save a visit for just before you close. And people don't understand the importance of saving that one visit just before you close and only using one visit prior to that. Is that something that you see a lot? They've already used up their visits and they have nothing to go on.
Yes, and what's actually really, really interesting about that is that a lot of people are under the assumption that they can actually go in and take contractors and bring in their extended family and their best friends to go and check out this amazing property they purchased, when that's not really what you're contractually entitled to. Your inspection is designed for you to go in to move carpets and move things around to make sure the property is in the same shape that you agreed to purchase it in. It's not intended for you to take in your family, your extended family, your best friend Bob. It's for you to go in and make sure that you're happy with what you're getting. And so I think when you're explaining the contract, the realtor's job when they're explaining that contract after drafting the condition and terms in the agreement is to express that this is a very important inspection, even though it's called a visit, and this is what we're intending on getting out of this inspection, and that this should be reserved very specifically for that purpose and not to be wasted, 2 months before the closing or a month before closing when everything really hasn't changed because the sellers haven't started moving out at that point.
Ricky, have you had situations where things do go horribly wrong after closing, after the move-in, and you do advise your clients to say, yeah, we should take legal action here?
It depends on the amount that we're seeking in damages. So a lot of people say, hey, we just want to go out and sue and sue and sue. And then you ask for what and how much. And so if a client can't substantiate the loss, then there's no lawsuit, right? To make a claim, you have to have damages sustained. So as an example, if the seller's not out on time after the deed's registered, well, my moving truck is now charging me $500 an hour or whatever it is to stand in front of the property and wait for these people to clear out so they can move in, right? That might be damages. The seller might not be out until late. Well, now I've got to go and, take out a hotel or whatever it is because I'm homeless and all my stuff is sitting in storage or whatever the case may be. So whatever your damages are, you can substantiate them. You are entitled to pursue those things. And if they're less than $25,000, it's a simple small claims court application. But again, if it's a couple $100, it's just not worth the aggravation. You have to really establish whether it's worth the effort or not. And more often than not, it's not worth the hassle. It's not worth the effort unless it's something serious and things have just gone really, really, really out of whack in context.
And that's not uncommon. I mean, the general rule of thumb is the seller should be out by about 6 p.m. But we've seen instances where sellers have taken till midnight, sometimes till the next day, and they just refuse to pack up and leave, even if the buyer has their moving truck sitting there. How do you handle that?
And you can call the police, you can scream out loud, you can do whatever you want. It is what it is. And again, they are in breach of contract for being in the property after the fact, but it goes down to the language in the contract. We know that once the deed is registered in favor of the buyer, technically the seller's in trespass. They should not be in the property. They don't have until 6 o'clock to move out. Once the deed is registered, they should be out of that home, right? But our contracts, generally speaking, don't address these concerns, and so sellers feel like they may be able to get away with certain things. And more often than not, the buyer's not going to take legal recourse. It's just a couple of hours or another night, and then they accommodate usually. But that's if the seller's being nice about it as well. Sometimes you get these, really aggressive and bullish sellers who think that they have the right to be there and they don't. And those are the situations where we see the buyer say, hey, you know what? We just want to go after these people now because of the experience. And we did sustain damages. And even though it's not a lot, we just want to make an example out of these people. Again, that's where your lawyer comes in, has to advise you, tell you whether it's worth it or not. But you make those decisions when they come up.
Yeah, one more for you. Electrical panel was double tapped during the home inspection. Seller refused to fix it. Buyer said, no problem. Can I fix it myself? Seller said, yeah, I don't care what you do. You've purchased the house. Do it after. During a visit, the buyer took in an electrician and had the electrical panel repaired. Seller found out and freaked out. Tell us something about what happens there.
You got no contractual rights to go in and tamper with the property until it's your own. I can give you another simple example. It happens more often than you would think. Buyer says, I've sold my home. I'm going to be in an Airbnb or I'm going to be in a hotel for the night. Do you mind if we move our stuff into your garage the day before closing? So these sorts of situations, until the property is yours, you should not be using it. And I see sellers who agree to these sorts of things, and sometimes you may not want to take on that additional risk or liability. What if something gets taken from the garage? What if there's a fire? Who's going to be responsible? And so everything comes down to the contract. Your particular example, the buyer had no right to do that unless it was in the contract. And if it was in the contract and I reviewed it before it got accepted, I would have made sure that was omitted. Because we don't want anybody tampering. We don't know what kind of electrician the buyer's bringing in, whether they're certified or not certified, whether they're going to be compliant or not compliant. And so the buyer can do what they want after the fact when they're insured and they're at risk and the seller is no longer exposed.
So, Asif, can you tell us the rest of the story? What happened with that one?
It actually turned into a larger case, and the buyer's agent was reprimanded for saying you cannot make changes or alterations to a property before taking possession because there's a lot of liability. The house is insured by someone else for someone else, and it's just not, you can't do that. I am surprised that they actually went in and even attempted that.
Mm-hmm. Wow.
I'm surprised the realtor authorized it and allowed it to happen. That's what surprises me on that one.
Yeah.
Realtor's there to safeguard the property during the showing. That's why they have to be present during these sorts of inspections and visits. And it's shocking that the realtor had nothing to say about it at that time. Very interesting.
Agreed. And the furniture thing we get all the time. Can we just move stuff in a week early? Our closing at this house is a week early. I'm moving stuff from another province. Can we store it in the garage? But that stuff's not insured because it's not part of the seller's insurance policy.
Nope. It's a cost of doing business. You're moving. Storage is relatively cheap. Take out a storage container, right?
That's right.
I usually don't advise my clients to agree to these sorts of things because they can become very troublesome. Now the buyer comes in and says, I need a dress shirt. I've got a job interview. Can I go into your garage and get it? Where do you draw the line? We don't need these sorts of headaches and hassles. It's a cost of doing business. Get a storage unit and use it.
It's like giving them the shirt off your back. Ricky, more great information this week. Thank you very much, and we'll talk to you next month.
Have a good one, guys.
Thanks so much. When we come back, we get to your real estate questions and this week's hot listing. And just a reminder, if you missed any part of our show, go to 1059theregion.com. You're listening to 1059 The Region. Stay with us.
Need to connect with Asif Khan from Remax Prime Properties? Call him, 416-985-KHAN. That's 416-985-5426. Or email asif@thehomeshop.ca. Now, back to On the Market on 1059 The Region.
Welcome back to On the Market, York Region's exclusive radio real estate show on 1059 The Region. I'm station manager